Welcome back to La Belle. Well, guys, new year, new judge, and new letter from our favorite, Sarah Boone. Oh, and this is a doozy. All right, let's go through this real quick. So it's written January 19th to the new judge, Michael Kranick. And so we'll begin. Honorable Judge Kranick, finally, a new judge. It's strange how the Lord works, as I was in the process of trying to disqualify Wooten after being my judge 4 years and me still incarcerated with nothing to show other than 7 different attorneys, not by choice, news clips of me walking in and out of the courtroom, and everything relative to my case permitted to be slathered on the global internet and in which I have not seen myself. I felt he was the ticket holder to my overly hyped, illicitly distributed, misconstrued, quote, criminal case. And great reason I am still here, again, ongoing 4 years and 7 attorneys later, not by choice. See my letter dated 6/29/23 on clerk's website. While still waiting to properly elucidate the court, public record, and world, and whatever the dysfunction was in the attendance part of my most recent pretrial conference status hearing, which I'm trying to ensure my automatic attendance futuristically. Please see my draft motion included. I am still trying to have my attorney submit on my behalf. So that sounds like she was not pleased she wasn't at that recent case management conference on the 16th of January. I wanted to bring to your judicial attention the following information so you and the world are aware of it, as not who I am ever delaying trial, as Wooten inappropriately accused me of in a past hearing, especially now you have mandated a trial date to be had in May, with no further continuances, leaving less than 4 months to put together and complete what should and could have been done already. What happened in all the 4 years prior? Please see all my correspondence online. To date, here we go. To date, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. To date, Mr. Hobson has only met with me one time for a total of 3 hours, and that was on November 7th, 2023. To date, no phone calls have been received by Mr. Hobson, as his phone does not work properly. For further immediate much-needed communication to be made between client and attorney. To date, I have mailed 5 letters to Mr. Hobson trying to communicate my urgent need to speak to him. Oh gosh, guys, I bet you we start getting those. To date, I sent 1 letter to the investigator in my case to contact Hobson to contact me and see if he can assist in correcting the phone problem, also to inquire when anyone is coming. To date, I feel I am not being included or heard or cared about in my case again, from the continued miscommunication again with Mr. Hobson, and time-consuming, undiscussed entries are being made on my behalf. The continuance I did not know about. The waiver of appearance I did not know about, along with other documents. And I never sent copies of anything filed, so I know. Well, that's not good. I hope that her attorney had let her know that he was filing the continuance. I keep trying to tell him about with no response, furthering the already massive dysfunction in my 4-year case. I was hoping in the pretrial conference status hearing on Tuesday, 1/16/24, I could at least play catch up in the courtroom for 5 minutes. So many of my attorneys have done prior, including Mr. Hobson, in the 1 court date I've had for a continuance of a continuance. That was that October 30th, 2023 hearing. To express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hobson about our missed pretrial conference status hearing. What's the status? Okay. To date, 1 out of 133 days and counting, attorney and his client have met. To date, 3 of now To date, 3,192 hours, attorney and client have discussed partial general case information. To date, I still have not seen my discovery. Your Honor, when is the next status hearing, please? Especially since we were not at the last pretrial conference status hearing, and especially since I am trying to communicate with my attorney in more than one way to fully maximize and utilize the minute amount of time allotted before trial. My fair, appropriate, lawful trial. I still am wondering why, though I've had to wait for 4 years for something to finally happen in my case, ask Judge Wooten. I wonder also, was I the oldest case on his docket? She should look at the Markel case, how long that's taken. Either way, I'm still here, waiting patiently and very excited to get this highly anticipated show on the road. I wait your overdue. How is the judge's response to her overdue? I await your overdue and very needed judicial direction, supervision, and intervention. Thank you in advance, Judge Kranick. Welcome. Sincerely, Sarah Boone. Oh, we've got a draft motion. Oh, okay. Well, look, she did a good job with the heading here. All right. Motion to be included in and allowed admittance to all defendants' pretrial conferences and hearings. Now, again, if Sarah wants to be at all of these, she should be at all these. And as I noted in the case, the video I just did on Sarah Boone, the prosecutor mentioned that to the judge as well, that this defendant likes to be at everything, and she has the right to be there, obviously. Okay, comes now defendant Sarah Boone by and through her undersigned attorney, Winston E. Hobson, respectfully requests permittance to attend all my pretrial conferences and hearings ongoing until the conclusion of my criminal case. Per federal, she's citing the federal rules. She should be citing Florida rules. But anyway, the following is stated to lawfully allow my inclusion, participation, and requested admittance. 1. The trial court may hold one or more pretrial conferences to consider such matters as will promote a fair and expeditious trial. The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. In support, the defendant alleges as follows. Oh gosh. These pretrial conferences are for my personal individual criminal case. If professional YouTubers, news channels, court TV, etc., are given permission and allowed entry to the courtroom for viewing, and the judge also is allowing the conferences to be streamed live with all the court minutes uploaded to the internet world, I, the defendant, should be included foremost. Okay, again, as I said, she has a right to be included in these, and if her lawyer doesn't know that now, he put on notice. But again, this is, again, a common thing with all these letters. Sarah does not understand Florida law. We are a sunshine state. Courts are open. All of this information is public record. And so the judge isn't allowing the conferences be streamed. That's the state of the law in Florida. I may not have regular, consistent updates or communication with my court-appointed attorney, and by attending all my pretrial conferences and hearings, I will know current status, important dates, casework being completed, changes in parties. There's no changes in the parties. Timeframes, expectations, all pertinent information I, the defendant, have a right to know, want, and need to regarding my case. All information is important, relative, and necessary to me. Okay. I am not consistently included in the certificates of service and sent copies of any documents being filed in court regarding my case as requested numerous times by the defendant in writing and verbally in the courtroom, neither by the judge, the court, or my attorneys. By attending my pretrial conferences, I will know what documents have been filed, need to be, and will be in my case. Another way I can know what is going on in my case and being worked on. There. In complete overall support, it is my right by law as an individual defendant and inmate to be included in any and all developments made in my case. It is also my right to finally achieve success in any way in every aspect possible in my case. By attending and being included in my pretrial conferences and hearings, Said success can and will be accomplished fairly, faster, properly. Wherefore, the defendant, Sarah Boone, respectfully asks the Honorable Court to grant my motion to be included going forward to all defendants' pretrial conferences and hearings. By Sarah Boone. And she did a certificate of service. Hey, you know what? Oh, and then the last page is just her thing. Hey, I give her credit. I mean, I know this happens a lot in jail that inmates tend to get excited about the law, but I mean, look, takeaways. It sounds like Hobson is not meeting with Sarah as regularly as she would like. Now, that, of course, does not mean Hobson's not doing work. We've seen him already file some motions on her behalf, including getting the additional income for the private investigator. He's got, as I mentioned, a motion pending about getting an additional forensic mental health expert. It doesn't sound like, though, that her attorney told Sarah that he would be filing a continuance, although I think everybody understood that they were not going to be ready to go to trial at the end of January. But I guess the lesson for him is that Sarah does not want to be left out of any of these conferences. So she has the right to be. But I also think it's very interesting that our judge now has a taste of Sarah, and we have not seen the end to the Sarah letters. So, never a dull day in the Sarah Boone case. I wanted to close this real quickly and get this out there in case anyone was interested. And I hope to see you in my next one. Bye.